Hey guys, today we're going to talk about the Limitation Act. Now, the Limitation Act imposes time limits on the cause of action. The purpose of the Limitation Act is to discourage delayed litigation years after the damage has been done. In other words, they don't want the plaintiff to wait forever to sue the person who has caused damage to him. They want it to be quickly resolved, so that's why the Limitation Act imposes time limits. So for actions in contract or tort, in case you don't know what is tort, you can watch the link below on what is a tort. Tort essentially is a civil wrong, okay? It includes things like negligence, nuisance, defamation. So for actions in contract or tort, Section 61A of the Limitation Act states that an action cannot be commenced more than 6 years after the cause of action accrues. For contracts, the cause of action accrues on the date when the defendant breached the contract. So for example, if the contract states that the defendant has to pay a certain sum of money on the 4th of July and he failed to, then the cause of action commences on 4th of July. The plaintiff has 6 years from 4th of July to sue the defendant. Or to give another example, if the defendant is supposed to transfer certain shares on the 8th of October, he failed to transfer the shares on the 8th of October. He has 6 years from 8th of October to sue the defendant for breach of contract. Now I'm going to talk about negligence, nuisance, and breach of duty that result in personal injuries. If a plaintiff is suing for negligence, nuisance, or breaches of duty where damages consist of personal injuries, the limitation period is either 3 years from the date the cause of action has accrued, or 3 years from the earliest date on which the plaintiff has knowledge required for suing for damages in respect of the injury, whichever is later. The reason for this two limbs, one is where the cause of action accrued, the second one is where 3 years where he has knowledge, is because sometimes the injury could be latent, okay? That means it's only a few years later after the negligent act where the plaintiff found out that he has the injury. For example, in a negligence case against a doctor, where the patient loses his eyesight, okay, due to the doctor's negligence performed during the surgery. But he was unaware that the doctor was negligent during the surgery, and 7 years later, he loses his eyesight. So he has 3 years from the time he realizes he lost his eyesight because of the doctor's negligence to sue the doctor, okay? So that would be, in this case, in this example, 7 plus 3 years. What about negligence, nuisance, or breach of duty causing damage other than personal injuries? For example, damage to house or damage to cars. In a legal claim involving negligence, breach of duty, nuisance, which does not involve personal injury, the limitation period is either 3 years from the date from which the cause of action accrued, or 3 years from the earliest date on which the plaintiff or any person to whom the cause of action was vested, okay, had knowledge, okay, required for bringing an action for damages and a right to bring such action, whichever is later. The same rationale for injuries applies. Basically, a person can cause damage to, for example, houses or cars or other property, but the plaintiff does not realize it until many years later. So he has 3 years from the date where he has knowledge that the negligence caused the damage to sue the defendant. In the case of causing death by a wrongful act, negligence, or default, the family of the deceased has 3 years to bring a wrongful death claim under Section 20 of the Civil Law Act, where the injured person would have been entitled to maintain an action and recover damages. So thanks for watching this video on the Limitation Act.